Good morning. This is the 2024 Case Law Update for Law Enforcement. My name is Arnold Hahnemann, Deputy Executive Director of the Colorado District Attorney's Council, along with my colleague Brad Turner, Staff Attorney. We will be covering a number of cases that have been issued by the United States Supreme Court, the Colorado Supreme Court, and the Colorado Court of Appeals. The topic areas will be Fourth and Fifth Amendment and a section on a case that dealt with some of the elements of a crime. So that'll be the substance of what we're covering in today's law enforcement update. The first section is United States Supreme Court cases, and the first case we'll talk about is United States versus Rahimi. The facts of this case are that Mr. Rahimi had assaulted his girlfriend, CM. She had ultimately obtained a protection order based on the assaults that Mr. Rahimi had committed against her. Texas granted that civil protection order. And when they granted that protection order, the court specifically found that Mr. Rahimi had committed family violence and posed a credible threat to the physical safety of his girlfriend and their child in common. As a result of that protection order, Mr. Rahimi's gun license was suspended for 2 years. After the protection order, he subsequently violates the no contact provision on at least 5 different occasions and is also charged with the new crime of aggravated assault with a deadly weapon against another individual. So Mr. Rahimi has got a history with violence and with using his gun. As a result of that, the United States government, through the federal U.S. Attorney's Office, indicted Mr. Rahimi with possessing a weapon while subject to a domestic violence restraining order, and the particular provision was 18 U.S.C. 922 G8. So this is a federal statute that is being challenged as part of this case. He moved to dismiss that indictment, claiming that his Second Amendment rights to possessing a firearm were violated, and there was a violation of his right to keep and bear arms. That motion was heard by the U.S. District Court. The District Court denied that motion. After that motion was denied, he decides to plead guilty. However, he decides to appeal his conviction to the Circuit Court, and that is also denied by the Court of Appeals by the judge. However, he decides to ask for an en banc review by the Circuit Court. So that's when all the judges of the Circuit Court hear the appeal. When the entire Fifth Circuit panel heard the appeal, however, they agreed with Mr. Rahimi and decided to vacate that violation in light of a U.S. Supreme Court, the Bruin case that had come out in 2020. As a result of the Fifth Circuit en banc panel overturning the prohibition and the conviction, the United States government appealed to the U.S. Supreme Court to hear that case. So what was the issue before the Supreme Court? Can the restrictions on possessing a firearm under that federal statute, 922 AG, when a person has a domestic violence restraining order in place, in fact be enforced against that person consistent with the Second Amendment? And the Supreme Court said yes. The vote was 8-1. Chief Justice Robert wrote the opinion. There were multiple concurrences written by some of the other justices, and the sole dissenting opinion was Justice Thomas. So here's the holding with respect to the case. When a restraining order contains a finding that an individual poses a threat to the physical safety of another, that individual may be temporarily disarmed from possessing firearms while the order is in effect. The Supreme Court, in its opinion, and Justice Roberts looks back to the historical foundation in terms of when the government was able to restrict the possession of a firearm. And since the founding of our nation, we have included provisions that allows the government to restrict a person from possessing a firearm or a weapon if, in fact, they threaten the physical harm to others by using or misusing those weapons. So in that historical context, the Supreme Court says that Section 922 8G fits within this tradition, and as a result, they overturned the en banc panel's finding for the Fifth Circuit, and the case is remanded back down to the District Court for findings consistent with the order. What this means for Colorado case law and for Colorado cases is, in fact, an individual can be restrained from possessing a firearm for a certain period of time if in fact a court makes a finding that they pose a threat to the physical safety of another, and that is a common finding in the issuance of our protective orders. The next case is going to be Smith versus Arizona. And in the Smith versus Arizona case, this is a case where Mr. Smith had been charged and convicted of various drug offenses, federal drug offenses. This case went to trial. There was testimony of a forensic analyst about the drugs that were part and parcel of the case. That testimony was from a detective or an analyst by the name of Longoni. He had testified with respect to what the drugs were that were located on Mr. Smith's person and what was in his possession, but that was based on the original testimony of a lab analyst who actually tested the drugs by the name of Rast. However, Rast did not testify at trial because Rast was no longer with the Arizona Department of Public Safety at the time of trial. So they're no longer employed by the state. They were not available for trial. At trial, Longoni testifies to the work that Rast had done. Smith gets convicted ultimately of those drug charges and appeals his conviction to the Court of Appeals, claiming that his Sixth Amendment right to confront the witnesses against him was violated, which is our confrontation clause, because that particular analyst who did the work, the actual work itself, was not present, and that was the lab analyst Rast. Rast wasn't there, he couldn't cross-examine her, claims it's a Sixth Amendment violation. Goes up to the Court of Appeals, and the Court of Appeals affirms the conviction on the basis that the analyst Longoni could present his own expert opinion based on Rast's work, because her statements were only used to help Longoni form his opinion and served as the basis of his opinion, but not to necessarily prove the truth of what Rast had completed. The Arizona Court of Appeals affirms that conviction, and Smith decides to appeal that to the United States Supreme Court. So what is the issue for the Supreme Court? The question is, when an expert witness restates an absent lab analyst's factual assertions to support his own opinion, is the confrontation clause violated in this case? And the answer is yes. The Supreme Court says when an expert conveys an absent analyst's statements in support of his own opinion, and the statements are used to support that opinion if they are in fact true, then the statements come into evidence for their truth. What we basically have here is hearsay statements. So the lab analyst Longoni is testifying to the work that Rast did, and Rast's work, if it's offered for its truth, and therefore serves as a basis for Longoni's own opinion, that is going to be a confrontation clause issue. So the Supreme Court says, listen, a state may not introduce the testimony out-of-court statements of a forensic analyst at trial unless that analyst is unavailable and the defendant had a prior opportunity to cross-examine that analyst. Otherwise, if that doesn't happen, the confrontation clause is violated. In this case, the court essentially concluded that the state used Longoni's testimony to relay what Rast had actually written down about how she identified and seized the substances, and he essentially became her mouthpiece. As a result of that, the Supreme Court says in this case the confrontation clause was violated. Case is remanded back down for the district court to consider the case in light of that violation. So the holding, again, and to be aware, you as an officer or a lab analyst or someone that is working within an agency would not be able to testify to some other analyst's or officer's work unless the defendant has an opportunity to independently cross-examine that person ahead of time if, in fact, they're not going to be available for trial. Otherwise, if they do, it's going to be a hearsay violation and a confrontation clause violation. The next case is Chiavarini versus City of Napoleon, Ohio. I think I'm mispronouncing that name. It's a difficult name, but there it is for you. In this case, Jessica Chiavarini, a jeweler, was arrested for buying a $45 stolen ring from a thief. Officers within that jurisdiction obtained a search warrant. He was a store owner. They obtained a search warrant, and he is ultimately detained for 3 days until he is arraigned, and he is charged with 3 crimes. 1 misdemeanor for receiving stolen property, one misdemeanor for dealing in precious metals without a license, and finally is charged with a felony for money laundering. At the preliminary hearing, the court finds probable cause for all three charges and sets the case over for trial. However, the case was ultimately dismissed because the county prosecutors in this case failed to present it to the grand jury in a timely manner, and the court dismisses all the charges. Nevertheless, Mr. Chiaverini files an action under 42 U.S.C. 1983, a Fourth Amendment malicious prosecution claim, alleging that there was no probable cause for one of the charges that ultimately led to an unreasonable seizure of his person. He was detained for 3 days, and his claim is that was an unlawful detention. And as you will recall, under the Fourth Amendment only governs reasonable searches and seizures, and if it's unreasonable, then an individual can bring a claim against a police officer for violating an individual's Fourth Amendment right. The district court in this case denies the 42 U.S.C. 1983 claim, voting in favor of the officers, and says, no, there's no violation of his constitutional rights. He appeals it to the Sixth Circuit Court of Appeals, and they also affirm that the officers did not engage in any prohibited conduct. They argue that the prosecution of these offenses was indeed supported by probable cause, based on at least the two misdemeanor charges alone. The Court of Appeals didn't look to the felony charge, the money laundering charge, arguing that, listen, there was probable cause for the misdemeanor charges, that's sufficient, and they didn't address whether there was probable cause for the felony, but that didn't matter. They affirm the conduct of the police officers. Mr. Chiaverini appeals that finding to the U.S. Supreme Court, and that's how we get the case to this level. So the issue for the Supreme Court is when an official brings multiple charges in one single criminal proceeding, yet one of the charges lacks probable cause, for example, in this case, the felony charges, do the valid charges, meaning the two misdemeanor charges that were supported by probable cause, insulate those officers or that officer against a Fourth Amendment malicious prosecution claim relating to the invalid charge? Can an individual still bring a 1983 action against those officers and that office if, in fact, some of the charges are valid, supported by probable cause, and one is not? And the Supreme Court says those valid charges cannot insulate the lack of probable cause for that felony charge. Their holding ultimately is that bringing one valid charge in a criminal proceeding does not categorically bar a Fourth Amendment claim related to another baseless charge. All parties in this case, when it got up to the Supreme Court, ultimately agreed to that issue, and so the Supreme Court argument was not very contentious. The government actually agreed and said, yes, we have to have probable cause on all the charges. If, in fact, one charge is not supported by probable cause and a person is, in fact, detained because of that, then there's going to be a Fourth Amendment violation. Now, what does a petitioner have to prove or demonstrate when they bring that charge? They have a burden of proving, or they need to demonstrate that the charge that was not supported by probable cause was, in fact, the basis for the seizure. So in this case, Mr. Chiaverini is going to have to prove, when the case goes back down to the lower court, was his seizure and detention based on the felony, or was it based on the misdemeanor charges? And the Supreme Court says the record before us isn't very clear. This was not addressed in the lower court, so we're going to kick the case back down to find out which of those three charges was the one that actually caused the seizure and the detention. That may be a difficult task to establish, because when you get probable cause for the basis of a search warrant and there's an arrest warrant, it's not typically broken out by charges. But the key holding here is that if, in fact, someone is arrested on a charge or a number of charges, and there's a finding that not all the charges were based on probable cause, an individual may be able to bring a 1983 action against the government for violation of that individual's Fourth Amendment rights. So just need to be aware, Supreme Court typically is supportive of officers when it comes to 1983 actions. The Chiaverini case, however, is demonstrating that, in fact, yes, an individual can bring a claim, a malicious prosecution type claim against law enforcement or prosecutors for unlawful seizure and detention. The next case is Diaz versus United States. This is another drug-related federal case that's charged under federal law with respect to drug activity. Ms. Diaz was stopped at the U.S.-Mexican border port of entry after she had gone to Mexico to visit her boyfriend, was coming back into the United States driving a vehicle. Within the vehicle, border authorities found 54 pounds of methamphetamine hidden within the car. It was in one of the door panels of the vehicle that she was driving. She was charged with importing methamphetamine, and as part of that charge, the government has to prove that she knowingly transported the drugs. It's one of the elements of the crime. At trial, or before trial, she claimed she had no knowledge of the drugs in her vehicle, indicating that she was asked to bring the vehicle in, didn't know anything about the drugs. Boyfriend didn't tell her anything about that. That was her argument anyway. And the government planned to call a witness at trial, or they did call a witness at trial. Homeland Security investigator, Special Agent Andrew Flood, would testify that in this kind of situation, when you're talking about this mass quantity of drugs, 54 pounds, worth over $300,000 in value, drug dealers do not trust traffickers with that amount of drugs without letting the trafficker or the person who is the courier to bring those drugs into the state or into the country without giving them some notice, hey, this is what you're transporting. So he came to testify at trial, indicating that, listen, she had to have knowledge because most drug traffickers let their couriers know what in fact is happening because there's a lot at stake here. She's found guilty at trial. On appeal, she claims that the federal government violated Federal Rule 704B, and that rule of evidence says that an expert witness is prohibited from stating an opinion about whether a particular defendant did or did not have a particular mental state, and the conditions that constitute the element of the crime or the defense, they cannot testify as it relates to that particular individual. Court of Appeals denies the conviction, says, listen, there wasn't any violation of Federal Rule 704B here. Diaz is not satisfied with that denial, therefore appeals it to the United States Supreme Court. That's why we have the case before us here. So what's the issue for the United States Supreme Court? Does a witness violate the Federal Rule of Evidence 704B when he or she testifies about what most people in a group, as it relates to drug couriers, would do or would believe, as opposed to a particular defendant? Is that an expression of the defendant's mental state? Is that a violation by the government to have a witness testify as to what most drug couriers and traffickers would do as opposed to an individual person? The Supreme Court says that's not a violation. Agent Flood did not testify specifically as to what Ms. Diaz thought or believed, but generally about most couriers and drug traffickers. Their specific holding is that expert testimony that most people in a group have a particular mental state is not an opinion about the defendant, and therefore does not violate that particular Federal Rule of Evidence 704B. He did not express an opinion specifically about her knowing about the transportation of meth, but instead testified about the knowledge of most drug couriers. Therefore, her conviction is affirmed and is valid. The next case is Garland versus Cargill. The facts of this case are that the Division of Alcohol, Tobacco, and Firearms, the federal agency, for a significant period of time took the position that semi-automatic rifles equipped with a bump stock were not considered machine guns. Then there was an incident that took place, and the ATF changed their course with respect to that finding or ruling when an individual in Nevada had fired on hundreds of people in Las Vegas, killing 58 people and wounding 500 or more. The ATF changed their position with respect to whether a bump stock that is attached to a rifle is considered a machine gun. The ATF proposed a rule to repudiate their previous guidance amended the rule to clarify that bump stocks are machine guns, and as a result of that, owners of bump stocks were ordered to destroy or surrender them to the ATF to avoid federal prosecution. Michael Cargill had or was the owner of a couple of bump stocks. He surrendered those under protest and filed suit under the Administrative Procedures Act, claiming that the Division of ATF or the Bureau of ATF lacked the statutory authority to issue that rule. He filed his motion with the Supreme Court, the District Court. The District Court at the trial level ruled for the ATF, claiming that it wasn't a violation of the Administrative Procedures Act. He appeals that to the Fifth Circuit, and the Fifth Circuit District Court affirms the District Court ruling, but he then asked for the entire Circuit Court panel to hear that, which is an en banc hearing. And the en banc entire Fifth Circuit panel overruled that individual judge and ruled that, in fact, the ATF did violate the Administrative Procedures Act. Federal government appeals that to the U.S. Supreme Court. The U.S. Supreme Court affirms the Fifth Circuit en banc panel, holding that the Alcohol, Tobacco, and Firearms Bureau exceeded its statutory authority by issuing that rule. The reasoning behind that, when they argued that the ATF exceeded its statutory authority, when it classified a bump stock as a machine gun, that it did so under 26 U.S.C. 5845 subsection B, and that was a violation of that federal statute. Their reasoning is that a semi-automatic rifle equipped with a bump stock is not a machine gun because it cannot fire more than one shot by a single functioning of the trigger. This phrase refers to the mode of action by which a trigger activates the firing mechanism. The Supreme Court looks at the particular language in that statute and says it doesn't quite meet the definition as to what is a machine gun, and that's based on the firing mechanism. Even if it could, it would not do so automatically. The court goes on to say that section 5845 subsection B specifies the precise action that must automatically cause a weapon to fire more than one shot. That implies a single functioning of the trigger, and when you attach the bump stock, that's not what is happening per the definition. Therefore, the definition that the ATF gave for a machine gun doesn't fit with respect to bump stocks. Cargill and that statute, rather the ATF exceeded the statutory authority given the definition and the way the language is written in 5845B. The next case is City of Grants Pass, Oregon versus Johnson. The facts of this case are that the City of Grants Pass, Oregon issued laws restricting public camping. City law prohibits activities such as camping on public property or staying overnight in the city parks. An individual who violates that provision can be subject to fines. If they have multiple violations, then they could actually serve some jail time or be imprisoned given multiple violations. A group of homeless individuals gather together and file a class action lawsuit claiming that the ordinance that Grants Pass, Oregon had passed violated the 8th Amendment prohibition against cruel and unusual punishment. They file their action in U.S. District Court, and the U.S. District Court judge agrees with the plaintiffs, citing previous Ninth Circuit precedent, which held that cities cannot enforce public camping ordinances against homeless individuals when the number of individuals exceeds the number of available shelter beds. So if, in fact, there are available shelter beds that individuals can access, if there's an ordinance that exceeds that number, then that ordinance would be a violation of the 8th Amendment against unusual punishment and cruel punishment. It goes up to the Ninth Circuit District Court. The District Court affirms, the Ninth Circuit Court of Appeals. The Court of Appeals affirms the District Court and claims that the camping ordinance is a violation. The City of Grants Pass disagrees with that and appeals that to the United States Supreme Court. What's the issue for then the Supreme Court? The Supreme Court takes up the matter, and the issue is, does a city's ordinance regulating camping violations in fact constitute an 8th Amendment violation of the Constitution? And their ultimate decision is that it does not. Their holding is that enforcing laws regulating camping on public property does not violate the Eighth Amendment cruel and unusual punishment provision. The Eighth Amendment, they say, focuses on the punishment that the government may impose after a criminal conviction, not on whether a government may criminalize a particular behavior in the first place. So in this case, the punishment that is imposed by this city, such as fines and temporary bans on public parks, did not qualify as cruel and unusual. The case is remanded for further proceedings. The import of this is that a city can indeed impose restrictions on individuals camping or undertaking other activities in public spaces. That completes the section on Supreme Court cases. I'll now turn it over to Brad to cover the Fourth Amendment.
Okay, and now for the most exciting portion of the case law update. We're going to talk about the Fourth Amendment searches and seizures from the Colorado Supreme Court. The first case we're going to get into is Dine, or maybe Diney. I'm going to say it's Dine versus the People. This case is about IP addresses and search warrants for those IP addresses. So law enforcement gets a tip, as law enforcement does sometimes, that an IP address was transferring some child sexually exploitative or sexual abuse material, CSEM as we call it. And they trace this IP address to a specific house where a woman and her son, this is very important, who was a registered sex offender, the son was a registered sex offender, these two people were living. The police obtain a search warrant. They think they got the right place, so they obtain a search warrant to search the house associated with this IP address. And they want to search it for the evidence of CSEM. During the search, they're kind of surrounding the house, and somebody pops out the back of the house. They exit through an unmarked door. The police have no idea who this person is, so they stop the person and they ask kind of who he is, what's going on. And the man says, yeah, I live here in this place. I live in a separate unit in the basement. A separate unit in the basement. But he also admits that he also uses the same IP address as the other people in the house. Some other important facts: this property was only a single family unit. There were no separate mailboxes, unit numbers. For all intents and purposes, the police really thought this was just one place. The police then later seized this man's computer in the basement. They decided not to get another warrant first. They could have done that. They decided not to. They thought they had PC based upon the IP address and the fact that the IP address was associated with the whole premises, and this man admitted that he was on the premises and that he was using the same IP address. Well, go figure, there was CSEM on the man's computer. And ultimately, this gentleman was charged with CSEM. He was convicted after a bench trial. Guess he did not want to do a jury trial in this case. And before the trial, he moved to suppress the CSEM. He argued that obtaining the CSEM from his computer violated his Fourth Amendment rights because during the search of the house, they should have had a warrant to search his separate unit in the basement of the house. The trial judge made a somewhat interesting finding. The trial judge said, yes, I think the search violated the Fourth Amendment, but I'm going to find under the inevitable discovery doctrine that when the police later got the search warrant anyway for the separate apartment, or the separate portion of the house, that they would have revealed this stuff anyway. Inevitable discovery. And the judge said, okay, I'm not going to suppress the evidence. Again, ultimately, he was convicted. The guy appealed this to the Court of Appeals. They had kind of a split decision on this. You don't need to know the different legal theories under which they decided that opinion, but I'll tell you that they believed that the search was, in fact, legal, and they had different, and they didn't even reach the question of inevitable discovery doctrine. The defendant didn't like that ruling, of course, because that affirmed his conviction, so he appealed to the Colorado Supreme Court. And the Colorado Supreme Court agreed with the Court of Appeals on this. They said that there was, in fact, this was a reasonable search under the circumstances. As we all know, Fourth Amendment, The lodestar, the North Star of the Fourth Amendment is reasonableness. And they said, we conclude that a search of Dine's apartment under this warrant was constitutional. And there's two key parts to this. The first part is they thought they were searching one place. This was an outer indicator. There was no outer indication the building contained more than one dwelling. They even specified in this decision, the Colorado Supreme Court noted that it was the property records listed this as single family. There were no separate mailboxes, no separate unit on the door. These were key parts of the Supreme Court's decision making. These were key facts. And then the second piece here is that Dine did tell the police that he lived there and that he used the same IP address. That's key, because the IP address is what sets the scope of the search. It sets the scope of the PC here. They found that because this house and this guy were within the scope of that IP address, he admitted it, therefore they are going to be able to search his portion of the place. They also did not reach inevitable discovery issue here, so is effectively overruling district court on that particular piece. I think on this one, it's important to remember a few things about the Fourth Amendment. Again, the Fourth Amendment says searches must be reasonable, that warrants must be reasonable, and the execution of those warrants must be reasonable. So it's not just enough that the warrant be reasonable and be based on probable cause. It also has to be that when executing that warrant, the police's actions have to be reasonable. When they're opening doors, when they're looking in drawers, all kinds of stuff. And that reasonableness is determined by the perspective of a reasonable officer at the time the warrant is being written and executed. So it's from the perspective of the officer. That also means from the information available to the officer at that time, not some later time after the officer has learned of additional details. It's at the time the decisions are being made. And so the takeaways from this are a few. If you're law enforcement and you know that there are separate units at an address, particularity requires you to specify the precise location you want to search. So the way this typically shows up is you're looking for an apartment in an apartment building. Particularity says you can't just search the entire apartment building for something. You really have to pick a spot and say it's this address, this particular place. However, as in this case, if you don't know that there are separate units beforehand, but you learn mid-execution that there are potentially other units, you can make a choice. You can pause, and you can obtain another warrant, or if your warrant, or if the additional place within what you're trying to search is within the scope of the probable cause of that warrant, like it was in this case, a search of an IP address of a place, then potentially you can just go ahead and search because that IP address in this particular circumstance allowed them to do so. And so this is really about your judgment. And I think, if you're going to write search warrants for IP addresses, make sure, and this was really key to the decision, the judgment of the court, make sure that it's about really, we're searching the place where the IP address is found. We're searching the IP address and not necessarily the people here. They could have very easily said, we're searching for this boy because he was a registered sex offender. We're going to search his computer. And then if they find somebody else popping out of the basement, they would not have been able to search because that would not be within the scope of the PC there. But because they kept it broad, they kept it based on the IP address, the guy admitted to being within the scope of that, they're able to search. Still, you could just get another warrant. That may be the safest play here no matter what. Almost, there's no, that CSEM is not going anywhere. It's on the guy's computer. The guy was outside. They had him outside of the premises at that point. He wasn't going to be able to delete anything. So they could have waited. They could have gotten another search warrant. So they kind of played a little risky here. Use your best judgment. So the next case is people in the interest of JG. That is a juvenile. That's why it is people in the interest of, and JG is just the letters there. The juvenile, I'm going to call him Johnny. In this particular case, Johnny decided that he wanted to commit some firearms offenses. He committed those offenses, and afterward, his high school, JFK High School, developed and placed upon him a school safety plan. This was when he was in 9th grade. The school safety plan required that he submit to daily searches of his person, backpack, whatever he was wearing, for weapons. That was designed to protect everyone else from Johnny. This was enforced every day of his 9th grade school year. Well, as you know, school years change, and there was a summer break, and he didn't go to school, and he wasn't searched every day, and then he goes back to school in his 10th grade year. But in this particular case, the first couple of days of his 10th grade year, they did not search him. And so I think Johnny thought maybe he was no longer subject to the school safety plan, or maybe the Supreme Court actually thought maybe he wasn't, he thought that too. So on the 3rd day when they searched him, they found a gun in Johnny's backpack, fully loaded handgun, and he was ultimately charged and convicted of juvenile possession of a handgun. This was his 2nd offense, because I said previously he in fact had some prior offenses. This was a felony. Now, before he was convicted of this, though, he tried to appeal. He said there was no reasonable suspicion to search his backpack. There's no probable cause to search his backpack because the safety plan was no longer in place at the time. Really key finding here is the trial judge disagreed with Johnny. And the trial judge said, no, I'm denying your motion to suppress the evidence because I find that the safety plan was in fact in place and in effect at the time, and that the safety plan did justify the search. So this sets up a Colorado Supreme Court case, because ultimately the Court of Appeals, I believe, had affirmed the trial court's ruling. Now, the Colorado Supreme Court upheld the search. And they did so under a 2-part test developed under a case called New Jersey versus TLO. And I don't know if folks remember that case, but that was actually a case of a person who, it was a person in a bathroom, and she was smoking in a bathroom, and somebody kind of smelled the smoke. They go in, they search her, they find that she has cigarettes in her wallet. They find some other things as well. And anyway, in that case, the Supreme Court found that a search of a student at a school must be reasonable at its inception, meaning at the time that they're searching, it has to be reasonable, and it has to be reasonably related to the objectives of the search. And the search itself has to be reasonably related to the objectives of the search and not excessively intrusive in light of the age and sex of the student and the nature of the infraction. So for example, what that second thing means is if somebody is smoking in the bathroom a cigarette, you're not going to be able to do some kind of strip search of a student. That would be inappropriate and intrusive, overly intrusive in light of the age and sex of the student and the nature of the infraction, that kind of thing. So in TLO, the initial search, the court found that was fine because there was reason to believe that this person had been smoking in a bathroom. In fact, they were smoking marijuana. They found in this person's purse associated paraphernalia, a wad of $1 bills. This was 1985. That was big money back in 1985. And a list that seemed to indicate money from other students, that these students owed her money. So that is where TLO comes from. And when they applied TLO in this case, they said under the same circumstances, or not same circumstances, but under the same law, that this search was ultimately acceptable. And they reasoned that a search carried out in accordance with the previously established safety plan is reasonable at its inception because a plan requiring daily searches necessarily diminishes a student's expectation of privacy. In other words, Johnny knew that Johnny was under a safety plan. Johnny committed firearms offenses. They're going to search him. When they're searching him all the time, you have basically no real reasonable expectation of privacy under that circumstance. So of course a search is reasonable to search his backpack. They also found, and this is absolutely key finding, the plan did in fact remain in effect. They relied very heavily on the trial court's judgment here, that they're finding a fact that it was in effect. They said that Johnny should have known he was still subject to the search requirement. Now, to be fair, the Supreme Court said the whole reason Johnny probably brought a gun to school on day 3 is because Johnny probably thought the school safety plan wasn't in effect. But they sort of took it out of his subjective belief. And they said basically it was a reasonable person would have known that the plan, because the plan from the previous year had not expired, that procedures were required to cancel the plan, and those had not been followed. And that Johnny had in fact been subject to an education improvement plan, and that plan had not lapsed, and Johnny knew that. And so Johnny had some sort of understanding that these kinds of things that exist, these plans, persist from year to year to year. And so they said Johnny objectively should have known about this. They also said this was important, that this was not a search, it was not based just upon the fact that he has prior criminal history. You can't base a search entirely off of someone having been a criminal in the past or having committed criminal offenses in the past. In this case, they said the safety plan was not based on just that. The safety plan was based on a variety of factors. This, folks, is where it's important that you rely on your multidisciplinary teams to help you develop school safety plans. They said it included factors such as his life, family, relationships, mental health history, and ultimately developing a plan for him. They found that this search was therefore reasonable in scope because all they did was search his backpack, and that's where they found the handgun. So they found that was appropriate search under the school safety plan. And ultimately, that's the takeaway. If you have a school safety plan, it's appropriately done. It's based on a bunch of different factors, and you consistently, or even if you don't consistently enforce it, as long as there's no expiration of this plan, the student has a lower expectation of privacy, you can search that student. The next case is People v. Johnson. So there are two folks in this one, two officers. There's a Deputy B and there's a Sergeant M. They're both observing an area. They're both kind of patrolling an area. And Deputy B observes a vehicle conduct an illegal U-turn. Deputy B says, "Hey, Sarge," Sergeant M, "I see this car. It did a legal U-turn." Sergeant M, who's also patrolling the area, sees the exact same thing. A different, separate, illegal U-turn by this vehicle. Sergeant M, who happens to be closer to the vehicle at that time, pulls this person over. Sergeant M appropriately asks for driver's license, registration, and proof of insurance. The defendant, well, suspect at the time, now defendant at this point, was not able to produce any of those things. During the stop, I think this was a Sergeant M, he notices there's an empty shell casing sitting in the front seat cup holder right next to this gentleman. The guy appeared nervous. We see this all the time, people talking to cops, but sometimes also indicative of other things. In this particular case, the defendant was also wearing a camouflage black strap bag, a camouflage bag that was strapped to his chest with a folding knife clipped to it. Now, you could probably ask any officer and watching this, what do they think's inside the bag? Ultimately, the guy says that he denies that there's the presence of any weapons initially, but he says, yeah, actually, I got a shotgun in the trunk. So all this is adding up for the officers. They have him step out because they're concerned about their safety at this point. They remove the bag and the knife. And at this point, this is key to the timing of this case, they call a K-9 unit to come out and sniff the vehicle. Now this guy is, at this point, he's not under arrest. At this point, he's Terry stopped. There's reasonable suspicion. They're pulling him out. They're going to do a pat down of his person. Exactly what they do next. Except, as Deputy B at this point is patting the defendant down, Deputy B feels what, this is important, immediately feels like a bulbous pipe in the defendant's pocket. It's really important because the case law says the only purpose for a pat down, for a Terry stop, is officer safety. You don't get to, it's not a search for paraphernalia. But if during that search, the pat down, the officer feels what immediately feels like contraband, you can't palpate it, you can't manipulate it. If you immediately notice that it is in fact contraband, then you are okay, you can use that to develop PC. So the police ask him about this. He says it's a pipe, it was his, and he said he used it the night before. At this point, officers arrest him. He's arrested. They Mirandize him. Further evidence that they are trying to arrest him. Deputy B then places him in the back of a police vehicle. Additional evidence that he is under arrest. He does admit in the back of the police vehicle that he does use meth. He used it to stay awake the previous night. This is all really key because it's later that while the defendant is still in the police cruiser, the canine unit arrives. Police aren't done with the scene at this point. They have the dog come out and they have the dog go around the vehicle, and the dog alerts to the driver's side. Officer opens the door. Dog alerts to center console. At this point, based on the alerts, they believe they have PC to search his vehicle. And they do. Surprise, surprise! They find 2 firearms. Not one, but 2 in the camouflage bag that was on this guy's, strapped to this guy's chest. They find meth in a jar in the console. They find meth in a bag on the passenger side floor. Not one, but 2 shotguns in the trunk. And then, as you often find with individuals who are smoking meth, they have a variety of ID documents on them belonging to other people. For obvious reasons, defendant is charged with a lot of crimes. Now, he says, you shouldn't have searched my vehicle. It was an illegal search. He says there was no reasonable suspicion, despite the fact that I U-turned twice, illegally U-turned twice. He said there's no PC to search, despite the fact that dogs hit. He admitted to using meth from a pipe in on his person. The trial court, however, agrees to some extent that there was reasonable suspicion to stop. They found that there was the trial court found there was probable cause to arrest. But the trial court said that he was held for too long in the patrol vehicle while waiting for the canine unit. The trial court said that while he was waiting in the car, he wasn't really under arrest. The trial court said really what happened is, at that point, all they had developed was reasonable suspicion that he wasn't fully under arrest at that time, and that therefore the trial court found that the amount of time he was being detained under reasonable suspicion, a Terry stop, was too long. And the trial court suppressed the evidence. Now, obviously, the people appeal this decision because it's just wrong. And here's where you get the Colorado holding. The Colorado Supreme Court overruled the trial judge, holding that once the officers had probable cause to arrest, that became a legal basis to further detain the defendant until the canine unit arrived. Now, what did the Supreme Court say about this so-called wasn't fully under arrest? It was really reasonable suspicion that was holding him, not the probable cause of the arrest. They said that was clearly erroneous. They said because Johnson was arrested, the officers had a lawful basis for Johnson's continued seizure. And the court erred by concluding his stop was impermissibly extended, and that accordingly the fruits of the search of the vehicle had to be suppressed. And this is key here. This is the rule you should take away. The development of probable cause to arrest stops the clock on an investigatory stop, whether a formal arrest has been announced or not. In this case, he was not waiting a long time for the canine unit under mere reasonable suspicion. He was waiting after he had been arrested. That's really important. So if you're waiting on a canine unit to come out there, you better do it quickly if it's reasonable suspicion. If the guy's already under arrest, you can keep him in the patrol car for a while you have the dog come out, do the sniff, so on and so forth. It stops the clock. That's the ruling here. I also want to point out that the court also agreed there was reasonable suspicion to stop this car. Of course there was reasonable suspicion. The guy he had 2 illegal U-turns witnessed by 2 separate officers. Also, during the investigatory stop, you can kind of see this kind of keeps progressing, right? They see the empty shell casing. He's wearing a bag that is often used to carry weapons. That has a folding knife attached. He admitted there was a shotgun in the trunk. You will notice, however, the court is not saying that he appeared especially nervous was evidence of reasonable suspicion. Just remember that. That's often, people are just nervous around cops. So it's one factor, but it's often overlooked or diminished in weight. So ultimately they said, yes, of course they have a reasonable belief that he was armed and dangerous. That's why they did the pat down. And ultimately the pat down was fine because it was a minimally intrusive frisk for safety purposes. And then that developed the PC. When they pat him down, they immediately felt the bulbous pipe. They immediately realized, he admits, yeah, I used meth. This is the pipe I used to smoke the meth. There was PC to arrest him. And that's ultimately what the court found. Next case is People v. Seymour. Now, there's a lot to this case. This case really is pretty significant in Fourth Amendment jurisprudence in Colorado. However, I'm not going to go through all of it because there's really one big takeaway to take away from this, and I'll give you that at the end. The facts are that fire burns down a Denver home, killing 5 people. The police suspected arson. Why? Because the fire department found out that it was started by an accelerant. And there's a surveillance video from a neighbor that showed 3 masked people carrying a gas can right next door just before the blaze. So pretty reasonable conclusion there. Police, however, exhaust their ability to identify suspects, to find out what happened. And when I say exhaust, I mean exhaust. They had nothing. They can't find a single suspect. So police turned to a tool that Google offered called a reverse keyword search. The idea being that the police would say, okay, let's identify all the people in the world within a set time frame who, I don't know, Google searched for this building's address, let's say in the 15 days prior to the building burning down. Pretty innovative, and that's what ultimately the police did. They issued warrants to Google. They asked for a bunch of information at first. Ultimately, Google said, we're not going to give you all that information because it violates our privacy policies. But police, ever persistent, continued trying, and they eventually asked them to produce, Google to produce, a list of anonymized devices that searched for the address of the home in the 15 days prior to it burning down and the IP address of those devices. Google complied with this, gave them a list, ultimately returned 8 anonymized accounts. 8. And there's IP address that searched for this address of this building in the 15 days preceding the fire. Only 8 people out of what were like essentially 1 billion records in Google's database. And ultimately, from this information, once you have IP addresses, all law enforcement know that you can start identifying individuals. So they did search warrants for the IP addresses. They found that 5 of the 8 Colorado addresses were Colorado IP addresses. That's significant. And then from that additional investigation, they ruled out of the 5 remaining, they ruled out 2. That left 3. Seymour, the defendant in this case, was one of those 3 remaining suspects. They charged him with quite a few crimes, including first-degree murder and other felonies. Seymour, of course, moved to suppress the results of the keyword search. He said this violates his 4th and, very interestingly, his First Amendment rights. Fourth Amendment being search and seizure, First Amendment being freedom of speech and expression. Now, ultimately, the trial court did deny this motion. He did appeal. And the questions before the Supreme Court were 4. Do you have a right to privacy in your internet search history? Was there a First Amendment right in the privacy of a search history? That's kind of a novel question. It's not kind of, it is a novel question. Was the warrant sufficiently particularized? In other words, were they searching for something particular enough? And was there probable cause to support the warrant as specifically to Seymour? That's really key here. Finally, fifth, is if the warrant did lack particularity or probable cause, was there an exception? Could they get this? Was this still legal, perhaps, by the good faith exception? Now, the Supreme Court held that people do have a reasonable expectation of privacy and therefore a privacy interest in their internet search histories, even if only through their IP addresses. Now, you'll recall we were talking about search warrants earlier for IP addresses. And you can connect these two cases together to some extent, although they're about to diverge. But they're saying that a person does have a privacy interest, if only, in their IP address. The Colorado Supreme Court also said, and by the way, that's a Colorado, the first one's a Colorado Constitution decision. That does not apply under federal Constitution decision because the federal rules say that there's something called a third-party exception. That whenever you expose your data to a third party, namely Google, that you cannot say you have a reasonable expectation of privacy in that data. That's federal law and federal Constitution, not Colorado law and Colorado Constitution. So the first point was made under the Colorado's Constitution, which they're saying is going further in protecting your liberty interests than the federal Constitution. The second one, they said that people do have, in both the federal and the state Constitution, what's called a possessory interest in internet search histories, the seizure of that data. The idea is, now normally digital data, you can take a copy of it, nobody would even know, potentially. But Colorado Supreme Court is saying that is, in fact, it does interfere with your privacy interests, or your possessory interests of your property, even though you did not possess this property, it was possessed by Google. So they're saying it was an individual's property on Google servers, and that law enforcement interfered with that property by violating that person's property right to exclude other people from that property. So they said it does, a person does have a property interest in their internet search histories, because, at least in the seizure of those things, because of that possessory interest. So the Colorado Supreme Court also said that Google's search history implicates a First Amendment's freedom of expression, which means that they have to evaluate any search warrants for search history with, I believe it is something like scrupulous exactitude or rigorous scrutiny or something like that. I actually don't remember what it is at the moment. It's not really relevant to what we're going to be taking away. In this case, they said the warrant was particularly sufficiently particularized, but here it's a very bizarre ruling where they said, we actually assume that it didn't have probable cause as to Seymour. The reason is because they said, there's some other case where they say you have to have probable cause as to the individuals you're looking for. It can't just be general probable cause. And so because this was a reverse keyword search, and there was no individual that we were tracing or tracking probable cause to or associating probable cause with, it couldn't possibly have had probable cause specifically as the defendant in this case. Contrast that with the previous case law I just talked about, where a search warrant for an IP address allows officers to search the premises of that IP address. And then if an individual who happened to be associated with that IP address, who they didn't know about, pops out of nowhere, that is fine, that's particularized, and that it's still within the scope of probable cause. This decision is different. They're saying that it lacked probable cause as to Seymour because they were searching an IP address, they're searching for people in a reverse manner, and then populating a list of IP addresses that way. So it's a very strange logic that they're using here. But ultimately, they're saying that because the law enforcement obtained and executed this warrant in good faith and relied upon the search warrant in good faith, that the evidence must not be suppressed. This is complicated. And the court says a couple of things that, frankly, I don't think make any sense. It says if the search parameters change in a future warrant, meaning somebody's doing reverse keyword search, and they, for example, to include terms that are more expansive or more intrusive, so too should a court's analysis of particularity. Okay, but then they also say they did not decide whether reverse keyword searches are constitutional. In reaching these conclusions, we make no broad proclamation about the propriety of reverse keyword warrants. As is often true when we examine what is reasonable under the search and seizure provisions of the federal and state constitutions, much as fact dependent, our finding of good faith today neither condones nor condemns all such warrants in the future. I will tell you the takeaway from this is I don't believe that for a second. They said if the whole basis of this decision is we think that it lacks probable cause as to the individual because a reverse keyword search doesn't search for an individual, it finds individuals to search for, and the only reason why that search was legal for this case is because it was a good faith exception that police didn't know that particularized warrant, that there was a privacy interest in IP addresses, and there was a privacy interest that applies to this whole thing. Therefore, they relied in good faith, and they couldn't have known that this would violate constitutional rights. Well, now we have this case. How could they possibly ever say again that there's a good faith exception here? Everyone knows now that there's all these privacy interests. They now have people v. Seymour saying that it was not probable cause as to Seymour. I think the takeaway from this case is we don't get to do any more reverse keyword searches, no matter what they're saying. Now, if you want to put one together and you want to try because you've reached a dead end on your case and you cannot get absolutely anything, try it. See what happens. Do your best. Consult as many people as you can about how to make sure that this complies with this Constitution. But I think, generally speaking, moving forward, reverse keyword searches under Colorado law are doomed. We got one. We got one, and this was it. Tar v. People. To talk about Tar v. People, I'm going to give you a history. There's a case, Supreme Court, United States Supreme Court decision that talked about implied consent. And this is a applied consent case, expressed consent case. Birchfield 2016 says implied consent laws are constitutional. It says right there you've implied your consent by agreeing to drive in the great state of wherever, Colorado, Connecticut. That implied consent is in fact consent. And we all know if someone agrees to have their blood drawn, that's constitutional. That's fine. You don't need a warrant in that case. In 2017, the Colorado Supreme Court, listening to the Birchfield decision, held in Hyde that an unconscious driver expressly consented to a blood draw and was not conscious to revoke consent. And they said, therefore, that warrantless blood draws pursuant to the expressed consent law are constitutional. However, Mitchell, the United States Supreme Court changed their logic on expressed consent laws. This is kind of a mixed decision. There's a plurality and there's a very strong dissent. And both really together read like the Supreme Court no longer believes implied consent or expressed consent is real consent. They say when the driver is unconscious and there is PC to draw blood, that exigent circumstances, not consent, almost always permits a blood test without a warrant. So they're saying that there is a search and that there has to be an exception to the warrant requirement in Mitchell. That's a very different logic than Birchfield. Colorado Supreme Court in Tar, that's the case we're talking about here, just relied on Mitchell to change to make the following finding, to make the following holding. Express consent laws express recognition that someone is permitted to revoke consent, meaning they're out there driving in Colorado, they've expressed their consent under Colorado's laws, they get pulled over for they commit a very serious crime that would allow them, or some crime that allows them to, the police officers to invoke expressed consent. The driver can say, no, I revoke my consent. We hold that a conscious driver can revoke consent otherwise given by the Colorado Express Consent Statute. When the driver revokes consent, police are generally required to obtain a warrant before executing any blood draw. The idea here is the express consent law even expressly talks about people revoking consent. It provides consequences when people revoke their consent. So of course, it assumes people are allowed to revoke their consent. All right, so Fifth Amendment is next, Miranda in custody, and Arnold Hahnemann.
Okay, we're going to talk about two cases in the Fifth Amendment, Miranda in custody and double jeopardy section. The first case is Garcia versus People. This is a case involving double jeopardy and whether, in fact, it was appropriate to charge the defendant in two different jurisdictions. In this case, Mr. Rafael Garcia murdered his estranged wife or his estranged wife's neighbor in Palisade, Colorado, and fled to Mexico in the summer of 1989. Colorado at the time unsuccessfully attempted to extradite Mr. Garcia from Mexico. But working with Mexico authorities, the Mesa County District Attorney's Office was able to compile a casebook of the crime of the murder and send that to Mexican authorities. In 2009, he was tried for the murder in Mexico and was acquitted of the crime. In 2016, he came back to the United States, and upon entering the United States, he was immediately arrested, subsequently tried for murder, and convicted in Colorado. He appeals his conviction, as is any defendant is allowed to do, and his argument was that he was already acquitted of that crime in Mexico, and he claimed that the second prosecution in Colorado violated his Fifth Amendment right on a prohibition against double jeopardy. In addition, he alternatively argued that Colorado has a statutory law that limits dual sovereignty from applying, meaning that a person can be prosecuted in double or two or more jurisdictions, and that statute preventing prosecution in Colorado should not have allowed him to be prosecuted given that he had the acquittal in a foreign country. That case goes up to the Colorado Court of Appeals, and the Court of Appeals affirms the conviction and say, no, there's no violation here. He then appeals to the Colorado Supreme Court and certifies that. And this case now is before us as the Supreme Court in Colorado reviewed it and issued a ruling. The issue for the Colorado Supreme Court is Garcia's second trial prohibited by statute under 18-1303? That statute talks about a second trial being barred by prosecution in another jurisdiction. And if it does prohibit it, is there any exception to a second prosecution that involves a foreign jurisdiction? And in this case, the Supreme Court says, no, there is no prohibition. Under both the U.S. Constitution and our Colorado state law, Mesa County was entitled to prosecute Garcia despite the earlier prosecution and acquittal in the country of Mexico. What happens in this situation when you have an individual who might be prosecuted in a different jurisdiction? Law enforcement entities in one jurisdiction are allowed to cooperate with another jurisdiction. Efforts between separate sovereigns without more is not a basis to say that he is prevented from being prosecuted. Now, there was a case called the Barkis case that explains when a dual prosecution in a different sovereignty can go forward, and there are certain exceptions for that. The Colorado Supreme Court said that Garcia's Colorado prosecution was not barred by the double jeopardy clause of the U.S. Constitution's Fifth Amendment, nor was it barred by our specific state statute, 18-1303, as that statute does not prohibit prosecution in Colorado following a prior prosecution in a foreign country. Importantly, the Barkis exception talks about if one federal or one jurisdiction is controlling another jurisdiction, they do all the work, they provide all the case evidence, they provide all the material, is that in fact going to be prohibited? In this case, his argument was, listen, the Mesa County DA's office did all the legwork, they did all the casework, they packaged everything and sent it to the state of Mexico, and therefore, since Mesa County did all the criminal investigation and prosecutorial legwork, that should prohibit the prosecution in Colorado. And the Supreme Court said that's not what happened here, even though Mesa County law enforcement assisted with giving the Mexican authorities much of the information. That is not sufficient on its face alone to be a basis to prohibit the prosecution in Colorado. So that prosecution was valid. The conviction is going to be upheld. The next case is People versus Bowler. This is a case that talks about the issues with respect to what is required for determining whether an individual is in custody, and is there a violation based on statements that are made by a defendant to law enforcement. Gets kind of detailed. I do have a back and forth with respect to statements made by the defendant and the law enforcement officers involved, so we're going to walk through that. In this case, Mr. Bowler had stabbed a roommate to death. It was a snowy March evening. It was cold outside, and officers respond to an individual walking down a 4-lane street in the middle of the night to conduct a welfare check. So Mr. Bowler comes in contact with 2 officers. The entire interaction with Mr. Bowler was about 6 minutes, and it was all captured on body cam. And so as a result of that, the Supreme Court is able to actually look at the body cam and do an individual assessment based on their own, in addition to the record that is submitted as part of the appeal. Officers, again, were conducting a welfare check only. They did not have any information upon that initial contact with Mr. Bowler that he was involved in a murder. They do obtain that information a little bit later. When officers come in contact with Mr. Bowler, they start to engage in conversation, and they ask a few questions. So we're going to go through the transcript here, and we'll talk about what's involved here. The first officer on scene, and there were 2 officers on scene, asks Mr. Bowler, "Hey man, will you step out of the road?" He's standing in the middle of the road, walking down in an unsafe manner. Mr. Bowler immediately asked the officer not to shoot. Officer Keith was that individual who was first on scene with the other officer. The officer says, "Listen, I don't want to shoot you, man. Will you step out of the road, though? Will you step on the sidewalk, bro?" A second officer who's on scene shines a light onto Mr. Bowler's person and reveals that he's got blood on his shirt and that extended onto his arms. So both officers are now aware that Mr. Bowler has got some kind of injury. So the officer asks, "Man, are you covered in blood?" Mr. Bowler's response is, "I'm covered in Jesus' blood." "Hey man, will you take a seat for me? Can you take a seat?" Mr. Bowler's response is, "Yes, sir." And then officer says, "Thanks, bro." Officer Keith asked, "What's going on?" And Bowler repeated that he was covered in Jesus' blood. When Officer Keith posed the question again, Bowler asked, "Are you the police officer in charge?" And Officer Keith responds, "Yeah, I'm in charge right now." And then I'm going to explain some of the actions. So at that point, Bowler asks if he could kick his phone over to Officer Keith so that Officer Keith could call and speak to Bowler's grandfather. Officer Keith, in response, says, "Yes, I'll speak with her shortly," and asked again about the blood. Bowler corrects Officer Keith and says that he was referring to his grandfather because Officer Keith had said, "I'll speak with her." Bowler corrects him and says, "I'm talking about my grandfather." Officer Keith then continues to ask Bowler about the blood. Bowler doesn't answer directly and instead references religious matters. He was carrying a Bible with him at the time he was walking down the street. And he says to Officer Keith, "See, if you knew the Word of God, you would know me. Since you don't know the Word of God, you don't know me." At the conclusion of his comments about the religious statement, he says, "I give myself up," before again asking Officer Keith, "Hey, will you speak to my grandfather?" At this point, Officer Keith puts on some gloves, ready to check him out, and says, "Where are you bleeding from, man?" Bowler doesn't reply, so Officer Keith asks him his first name, and Bowler gives his first name. And therefore, Officer Keith follows up and says, "Listen, do you got anything behind you that's gonna hurt us at all?" Bowler replies he had some keys on his person. Officer Keith then says, I need the medics to check you out, and asked if that was cool. So he's asking him a question. Bowler acknowledges and agrees to that. Then after apparently being notified that Bowler had actually been suspected in the nearby killing of his roommate, Officer Keith and Officer Butler immediately tell him to put his hands behind his back. They handcuff Bowler and they place him under arrest. Throughout this entire interaction, no Miranda advisement is given. Bowler at trial files a motion to suppress, reasoning that he was in custody during this interaction with Officer Keith and Officer Butler. He should have been Mirandized. There was a Miranda failure. There's a Fifth Amendment failure, and he appeals that, saying there's a violation. Trial court agrees with that and suppresses the statement, reasoning that, in fact, Mr. Bowler was in custody when the officers were talking to him. The people appeal that court order to the Court of Appeals, or rather to the Supreme Court directly. They skip the Court of Appeals. As a reminder, when we have suppression issues, the prosecution is able to appeal that directly to the Supreme Court, to the highest court in the state, because it's a constitutional issue. There's no reason to go through an appellate level, go directly to the Supreme Court to determine whether the trial court made an error or not. The Supreme Court has jurisdiction to hear the appeal and rules on the matter. So what's the issue for the court? The Supreme Court has to address whether Bowler is in fact in custody for purpose of a Miranda and whether or not such statements should have been suppressed. And they argue that they should not be suppressed. All that interaction with Mr. Bowler should come into evidence. So what do they look for when making that analysis? There's a case that is out there called the Matheny case. That case has been around for a number of years, and the court refers to that as what we also call the Matheny factors to determine custody. There's 9 specific issues or areas that the court's going to look at to determine whether, in fact, Mr. Bowler is in custody. And I'm just going to walk through this. The first is the time, place, and purpose of the encounter with the suspect or the defendant. Who are the persons present during the interrogation? In this case, we've got 2 officers present and just Mr. Bowler. And fortunately, we have all of this interaction captured on body cam. The words spoken by the officer to the defendant. What was the exchange going back and forth? And what was the officer's tone and general demeanor when engaged in that conversation? How long and what was the length of the interrogation and the mood of the interrogation? In this case, I said it was 6 minutes. And from what I've described and what the opinion tells us, this was a conversational kind of interaction. Whether any limitations of movement or other forms of restraint was placed on the defendant during the interrogation. At one point, Officer Keith did tell or did request Mr. Bowler to sit down on the sidewalk. And so there is some form of restraint, at least the trial court is reasoning, that he's restrained at that point because he's told to sit down on the sidewalk. The officer's response to any questions asked by the defendant. Well, in this case, Mr. Bowler asked Officer Keith, hey, will you call my grandfather? Number 8, whether directions were given to the defendant during the interrogation. Hey, will you mind stepping out of the road? Will you sit on the sidewalk? In this case, the trial court reasoned that that was a specific direction given to Mr. Bowler as opposed to a request. And then number 9, the defendant's verbal or nonverbal response to such directions. Well, clearly we have both happening in Mr. Bowler's case. He's physically moving after being told to do so. He's asked particular questions, and he's asked questions about his name and identifying information. Weighing all these factors, the Supreme Court says, actually, Mr. Bowler was not in custody. The trial court's suppression order is reversed, and the case is remanded back down for trial. The important takeaway, and we've talked about Matheny factors over the last couple of years, and again, this is because trial judges do that weighing of those 9 factors and sometimes come out on the wrong end. We've had the Supreme Court once again referring to the 9 factors that a court needs to look at, but these are also the same 9 factors that we as prosecutors and you as law enforcement need to identify and respond to when you have a case involving an individual making statements. So my admonition or recommendation to you again is whenever you have a case that's going to involve documenting statements back and forth that are ultimately resulting in an arrest, when you're writing your narrative or your affidavit, that you should pull out those Matheny factors and have them available so that when you're writing a report, you're addressing some of these factors, so then when we go to a motions hearing and have to challenge that suppression motion, we can ask you questions, we can pull out the Matheny factors, and we can go through it systematically. And if you've written your report to address those particular 9 factors, that motions hearing is going to be much smoother, and it will help an appellate court if they have to review what happened at trial and the transcript, that the actual report reflects this interaction. And again, just an advisement with respect to when you're dealing with the case involving statements from a defendant. The last section is crimes and elements, and I'm going to hand it over to Brad to finish up.
All right, next case up is People v. Johnson. So this is a pretty bizarre guy. He's driving in his car down the road. He sees this 10-year-old walking her dog. And so he decides he's going to drive on the other side through around into the opposing lane of traffic to pull up his truck beside her. Now, he starts talking to her as she's outside the truck, and he's still in this truck. He asks for her name. He asked for the dog's name. He asked her for her name. He asked her for her age and her address. Obviously pretty alarming. Upon hearing her answer to this, Mr. Johnson remarked that, quote, 10 was the perfect age for a boyfriend. Then he asked her if she had ever touched it. Alarmed, the 10-year-old walked away. Based on these events and some other evidence from other cases, surprise, surprise, he has a history of this kind of conduct with a 5-year-old girl in Louisiana. Ultimately, the jury convicted Mr. Johnson of enticement of a child under 18.3.305. Now, that's important because this case is about that specific statute, that specific crime. Now, the Court of Appeals said they analyzed his attempt to entice a child under the inchoate, meaning the incomplete version of that crime. They said, well, you have to have a substantial step that strongly corroborates a person's intent. That's what the inchoate of intent requires. And they said, we don't find the evidence is sufficient under that standard to convict him of enticement of a child. However, the Colorado Supreme Court disagreed. And they reversed the Court of Appeals. They reinstated this guy's conviction. And they said the attempt language in 18.3.305 is not the inchoate of attempt. That's under 18.2.201, like attempted assault or attempted theft or something like that. It's not the same. They're saying that under this statute, enticement of a child, that attempt in this context means in accordance with its plain and ordinary meaning, to make an effort to invite or persuade. We conclude that a reasonable person would have found the combination of Johnson's words and conduct in the light most favorable to the prosecution amounted to an attempt to invite or persuade this 10-year-old child to enter this man's truck. They also said the same evidence could support a reasonable person's conclusion that Johnson acted with intent to commit unlawful sexual contact. So the takeaway from this is actually pretty straightforward. When you're dealing with the enticement of a child part and you're talking about the attempt, you're talking about a different version, not the inchoate, but this particular definition, to make an effort to invite or persuade. And under these facts and under that law, this man was guilty of doing so. And that's it. Thank you very much for your time.